help people in their life.
I'm Deborah Rodriguez. President Biden met with the Pope at the Vatican today. When it was over, Mr. Biden said it was wonderful.
No American journalists were allowed inside the 90-minute meeting, but footage edited and released by the Vatican showed the president introducing the Pope to his senior aides.
This is Michael Donlin.
The president's physician, Kevin O'Connor, also got an introduction.
He is my doctor.
Mr. Biden was seen giving the Pope a command coin bearing the insignia of the Delaware National Guard unit, in which his late son, Beau, served.
You are the most significant warrior for peace I've ever met.
Stephen Portnoy, CBS News, with the president in Rome.
A statement from the Vatican says the two men discussed climate change, healthcare, and COVID. New York City officials are bracing as thousands of essential workers face the possibility of unpaid leave if they don't meet today's mandate for COVID vaccinations. This firefighter says he gets it.
I've got the vaccine myself personally, but still, it's a freedom of choice for some of these guys.
CBS's Laura Podesta.
The firefighters union says as many as 20% of fire companies could close, and the ambulance fleet would be impacted as well if the mayor does not budge on his mandate. The city's police force could also be affected. Roughly a quarter of officers still haven't gotten the shot.
A powerful storm system's dumping mid-Atlantic states. Gusty downpours. This woman in Baltimore says she's prepared.
It's already gotten sandbags out or moving supplies that could potentially get wet.
Forecasters say the region could suffer its worst coastal flooding in 18 years. Many public schools are closed. Americans are making more, but spending less. CBS's Jim Krasula.
U.S. consumer spending rose just 0.6% in September as we faced rising prices and supply shortages. At the same time, a key inflation barometer that is closely followed by the Federal Reserve surged more than 4% last month from a year earlier.
The Labor Department says wages and salaries jumped 1.5% in the third quarter as companies offered higher pay to fill a near record number of job openings. Top sports kingpins earning a pretty penny.
The Vince Lombardi Trophy is staying in Tampa Bay.
Correspondent Steve Capen has the story.
The New York Times reports NFL Commissioner Roger Goodell made a total of nearly $128 million in salary, bonuses, and other benefits over the league's past 2 fiscal years. The figure emerged at owners' meetings that just wrapped up in New York City, and it makes Goodell one of the top 5 paid CEOs in the world.
The Dow is up 32 points. The S&P is off 9. This is CBS News.
There's always something new under the sun. CBS Mornings, weekdays on CBS.
Guys, stop putting your love life on hold. U.S. Pharmacy has some exciting news. If you've been wanting to try Viagra or Cialis, now's the perfect time. Call today and receive 90 little blue or little yellow pills for only $119 with free shipping. Why order some low-dose sildenafil from one of those subscription services when we can give you what you want now? Call 800-711-6818 and we'll rush your order discreetly packaged to your door. 800-711-6818.
There's a confusion about how to protect yourself from COVID. But one thing is for sure, whether or not you're vaccinated, you need an accurate thermometer. Contact your medical provider at the first sign of fever, the leading sign of COVID and the flu. Only the Exergen Temporal Scanner Thermometer has been proven accurate in more than 100 clinical studies. Be vigilant and don't rely on non-contact thermometers. They have no scientific studies behind them and can miss the fever that might mean COVID. Learn more at Exergen.com.
Could it be a newly uncovered ancestor of modern humans?
The new species is called Homo bodoensis. The name comes from a 600,000-year-old skull found in an area of Ethiopia 35 years ago. A study recommends dumping a couple of other names as anthropologists make new discoveries about fossils that are hundreds of thousands of years old. The new species would apply to the human ancestor that lived in Africa and some areas of Southeast Europe, though some specimens in that region would be reclassified as Neanderthals. Those from East Asia belong to a third group that's yet to be named. Wendy Gillette, CBS News.
Don't skimp in the candy aisle. Trick-or-treaters, classroom celebrations, and town parades are back after last year's smaller, socially distanced Halloween activities. The bottom line is, bye. Deborah Rodriguez, CBS News.
WPTV's First Alert Weather on WPSL is brought to you by Seacoast Air Conditioning. Family owned and operated on the Treasure Coast since 1982. Online at seacoastair.com. Now with a look at our forecast, here's meteorologist James Wheeland.
Happy Friday to you. Cold front moving through the area today. We'll have clearing skies, turning windy and less humid with high temperatures into the mid-80s. Tonight, partly cloudy, isolated quick shower possible. Otherwise, a little bit cooler, mid to upper 60s. The weekend, fantastic. Highs near 80, low humidity, lows low 60s. I'm WPTV First Alert meteorologist James Wheelan for WPSL 1590, the talk of the Treasure Coast.
At Seacoast Air Conditioning, they believe in 3 basic fundamentals: answer the phone, show up on time, and fix the problem right the first time. Seacoast Air, family owned and operated since 1982, waiting to answer your call 24/7.
Comfort crisis, don't roast, call Seacoast.
The high school football game of the week on WPSL and WSTU heads to Port St. Lucie High School with the Jaguars hosting the South Fork Bulldogs at 6:45 p.m. Join Dan Cuomo and the Mets' Adam McDonald for the game of the week. High School Sports 2021 is brought to you by St. Lucie Draft House, Nice Air, Stimmels of Stewart, South Florida Orthopedics Halftime Show, Indian River State College Athletics Department, Hoskins Turkle, Lloyd & Lloyd, Seacoast Air Conditioning, Max Stuckey, a proud love of Notre Dame, and Antojitos Mexican Restaurant in Fort Pierce.
Do you have issues on the job with wages or overtime, family and medical leave, disability issues, discrimination, or sexual harassment? Do you have a landlord and tenant problem or have a contract dispute? Have you been defamed or have your civil rights been violated? Hello, I'm attorney Stuart M. Address, and for more than 30 years, I've been fighting for the rights of everyday people. I believe in aggressive advocacy combined with personalized attention. That means being available to my clients. It means answering emails, sometimes at 3 a.m, and checking my messages over the weekend. It means caring about you. If you want to speak with a lawyer who will not be intimidated and who will actually care about you, call my office, Stuart M. Address, PA, at 772-781-8003, or send us a message through our website at www.stuartaddresslaw.com. We will respond to your calls and messages because we care. Our office is in Stuart, Florida.
You're listening to WSTU Stuart.
This is WPSL Port St. Lucie.
The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
This is Stuart Address, and welcome to a edition of Ask a Lawyer.
I love your costume.
Thank you.
Yeah, I mean
I have more of a costume on Facebook Live.
Well, you're for folks who are not watching on YouTube, you're wearing a Scales of Justice hat, which is kind of cool.
I am.
Yeah.
Okay, I'll take your word for it. Anyway, it's not going to be a real Halloween show. I could have come up with some goblin lawsuits. Didn't think about it till the last moment, so maybe we'll do that next Friday. Today is a little bit more about things that may impact many of you. Some aspects, some very specific aspects of landlord-tenant law. Let me tell you something that happened to me yesterday. I got a call from somebody I knew very well who's having a landlord-tenant problem in Georgia. Now, I am not a Georgia attorney, and I take very seriously and very carefully giving any advice about law outside of the state of Florida. But given the relationship I had with this person, I did look up the Georgia landlord-tenant statute and give him some advice on his entitlement to security deposits under Georgia law, and let him do with it as he may. But that got me to thinking about Florida's landlord-tenant statute, with which I'm fairly familiar, and which has very specific requirements for both tenants and landlords. And unfortunately, if either is not aware, there are landmines that can explode in your face. So let's talk a little bit about the Florida statutory scheme. Now, this first part, this is for security deposits. You know, that money you put down at the beginning of your tenancy, not for the last month's rent, but as security for any damages that you may cause while you're living in somebody else's property. So at the beginning of your tenancy, under Florida law, a landlord must provide you with a written notice within 30 days of you taking possession of the property and of him or her or it receiving a security deposit as to whether that security deposit is in an interest-bearing or a non-interest-bearing account. Now, of course, there are always exceptions under any law. And so if you're a really small landlord, it may not apply. If you're renting out your own house, it may not apply. But in general, this is the landlord-tenant law. And if the landlord fails to timely mail you that notice, then there's a very significant consequence to the landlord, because the landlord must return your security deposit in full when you end your tenancy. It cannot deduct from that security deposit for damages, even legitimate damages. Why? Because it failed to provide you with that written notice. Now, that doesn't mean that the landlord cannot sue you for damages, but the landlord cannot deduct from your security deposit. You get it back in full. Now, if the landlord does try to collect from you under the security deposit, gives you less than your full security deposit back, and had failed to give you that notice in the beginning, you can sue the landlord for a refund. And all this is done, you know, in what is essentially small claims court, landlord-tenant court. So it goes very fast. You don't need an attorney, not unless it's something really complex. For something like this, it's relatively simple. You didn't give me that notice, give me my refund. Either the landlord is going to produce the notice or not. So that's at the beginning of the tenancy and consequences to the landlord of failing to provide that initial notice. What about the end of the tenancy, which is where the problems usually occur? Once the tenancy is complete and the tenant has returned possession of the property back to the landlord, then the landlord must return the entire security deposit within 15 days if the landlord doesn't intend to hold any portion of it for damages. Now, let's unpack this. By 15 days, a landlord will have inspected the property. By 15 days, a landlord is going to know whether it is going to claim any money. It may not know exactly how much. It may have to make its itemized list, but it knows whether it will or will not be collecting any money from the security deposit. So if it's not collecting any money from the security deposit, it has to refund that security deposit to you in 15 days. Now, what if the landlord does intend to deduct something from that security deposit? Well, then the landlord has 30 days to provide you with a written notice of the amount that's going to be deducted, why it's going to be deducted, and the amount for each type of deduction. This statute specifies a very specific notice that the landlord must send to the tenant. Greg, you were going to jump in.
Yeah, Stuart, is this a new law or has it been on the books a while?
This law has been on the books for a while. There was one aspect we're going to discuss which changed really because of COVID, but no, this law has been on the books for quite some time. So that notice that the landlord has to supply you if it's deducting any money within 30 days reads like this because it's letter by letter, word by word, the statute required. This is a notice of my intention to impose a claim for damages in the amount of X upon your security deposit due to blank. It is sent to you as required by statute 83.493. You are hereby notified that you must object in writing to this deduction from your security deposit within 15 days from the time you receive this notice, or I will be authorized to deduct my claim from your security deposit. Your objection must be sent to insert landlord's address. Now, so let's look at this really carefully because I've seen too many tenants get caught in this spooky web. The landlord sends you a notice within 30 days. The landlord's notice complies with the statute. It tells you what deductions are going to be made, $50 for cleaning the walls, $20 for repairing holes, whatever. You now have only 15 days to send a notice to the landlord. All it has to simply say is, I object, I disagree. You don't have to explain it. You don't have to attach 100 pictures. You don't have to do anything other than get that notice to the landlord on time.
Wow. That's really amazing. We got a letter from an attorney in Boca. And, you know, when we moved here from Los Angeles, we leased a home for a couple of years before we found the house we wanted to move into and are still in. And I guess the leasing company went bankrupt and we never got our deposit back. And apparently this lawyer says it's just sitting there. Do you want us to get it for you? Of course, they're obviously going to charge a fee for it, but I was shocked to see something like that. I didn't.
Well, see, that's a slightly different situation. Greg is saying that he rented a place once and the landlord went bankrupt. And so he never got a refund of his security deposit. And one day he gets a letter from a lawyer saying, you know, your security deposit is sitting available to you. Do you want me to get it for you? Of course, for a fee. Something that Greg could do on his own, frankly. You can collect your own money. But the lawyer is telling you something that you didn't know. You realize the money's there, and okay, makes life very easy. Yeah, and bankruptcy, all sorts of rules go out the window, and all sorts of new rules come in. Bankruptcy rules of which I am totally unqualified to speak. What I typically would tell a prospective client or a client is, all right, I now have to refer you to this bankruptcy lawyer. You know, call him or call her. You know, I can remain involved on the periphery if the bankruptcy lawyer has questions. You know, needs things like the lease, proof of payment. But I'm not in the bankruptcy court. I was there once and I wasn't happy. It was alien to me. So folks, if you are a tenant, we get so many calls. You know, I moved out. I don't know if the landlord's gonna give me my security deposit. What can I do? I moved out and I haven't got my security deposit back. What can I do? Well, and the answer is, have you waited 30 days? Well, no. All right, give it 30 days. Call us back if you don't get a notice and your money back. But if you do get that notice, 15 days, folks, if you disagree. Now, if I am involved with somebody at or near the beginning of a tenancy or even in the middle of a tenancy, I'm telling them, take photographs of the entire house, or just walk with a video camera, your phone, videotape the entire house. Because then if the landlord says you put a hole through the living room wall and you say, no, I didn't. Well, how are you going to prove that in court? Especially if all of a sudden there's a hole in the wall. Well, if you can show the video of when you moved in and you can show the hole in the wall, or you can show a video of when you left, which I also recommend people do, or photographs, and there is no hole in the wall, you're going to win that argument. So making a record of everything is fundamental, especially in today's era, today's society. You move in, you do that little checklist with any good landlord, but that's not enough. Walk around with your own camera, take photographs, videotape, your tenancy, your residence, and do it again before you leave. I mean, look, folks, videotape the damn toilet, videotape it flushing, videotape the sink. A lot of landlords have lots of complaints about bathrooms. Show that you left the bathroom the way a bathroom's supposed to be left. Show that you left the kitchen the way a kitchen is supposed to be left. And this way, you're going to get your full security deposit back. And if some unscrupulous landlord wants to try to cheat you out of some of it, you're going to have what you need to show a judge in landlord-tenant court that you left this place spotless.
Yeah, it's no he said, she said type thing.
No, he said, she said. I despise he said, she said. As a lawyer, I've been doing this 36 years. I despise it. Not because, folks, you're wrong, but because it's so hard to prove. I have had he said, she said cases of the landlord and non-landlord tenant variety. They are no fun because you have no idea who is going to be believed. You don't have the advantage of trying to move that needle by having evidence. A real quick example. This is one of those war stories, so I'll make very, very short. It's a good long story. But, we had a couple who got into a little altercation with the police in Broward County. And it ended up, they were pulled over in the parking lot after a hurricane. And both the husband and the wife got tased in front of their young children. And we sued for civil rights violation. Now, if it's going to be, he said our clients, and he said all the cops that showed up, well, who do you think the jury is going to believe? But lo and behold, we had some evidence. We had a former New York City detective walking out of a bagel store at exactly when all of this went down. And that New York City detective testified in federal court that all of the cops were lying. Imagine that. That is pretty good evidence. And when I was making my argument to the jury, I focused not just on that we had a witness, but we had a witness that had every interest in supporting the police, every motivation to support the police. And yet here he was testifying against them. That's evidence. And so what I'm suggesting to you is, in the landlord-tenant context, pictures, video, whatever, prove what it was like when you moved in, and show what it was like when you moved out. And you are most likely to avoid a problem which unfortunately plagues many, many tenants, which is a landlord that tries to take part of your security deposit, especially for things that they're not allowed to take it for. They're not allowed to take it for ordinary wear and tear. If they say the carpet needs to be shampooed, well, yeah, the carpet needs to be shampooed. A new tenant's moving in. The carpet should be shampooed. Now, if they say there was a stain on the carpet in the master bedroom, and that stain's been there for 20 years, was there when you moved in? I hope you can prove it. Because if you can't, you're probably going to have to pay for new carpeting if the shampooing doesn't work. So really, can't emphasize enough. Tell your friends, tell your family, tell everybody. If you're renting a place, start with the photos, start with the video. It's never too late, and do it when you leave too. Now, let me finish this one section. I'll go to Greg by telling you, if the landlord fails to get that notice to you within 30 days, it comes on day 31. The landlord has forfeited any claim to your security deposit. I don't care if you destroyed the place. If that notice comes on day 31, you are entitled to your entire security deposit back. And the landlord can't sue you for the damages. So these timings are very important. And of course, the average person, doesn't know the deadlines in every statute of every type, of every sense, and neither do I. But these are important because they affect probably a lot of you or a lot of people you know, or people you know of people you know. All right, Greg, what do you want to say?
Well, and as you mentioned earlier, the quality of the video out of these brand new phones is absolutely phenomenal. And, just keeping that file is so easy.
Absolutely. Today with thumb drives, toe drives, hard drives, detachable, undetachable, whatever you want. There are so many ways to store information, even if you want to get it off the device you originally took it from. Keep that information until you absolutely no longer need it. Not until you think you don't need it, until you absolutely don't need it. We have a caller on line 1. Oh my goodness. We have Gloria. Hey, Gloria. Gloria, speak to me.
Hello, Mr. Attorney. This is
Hello,
Gloria,
Ms. Prospective client.
I'm just calling it not on your subject at all, although it's very interesting and you look lovely. But I'm calling to thank you very much for a wonderful evening watching my grandson in the grand ballroom and having a pleasant evening after and a lovely morning. And I just wanted to say thank you so much. It was very enjoyable, and I hope we do it again soon. Thank you.
You're welcome, Gloria. And folks, let me tell you, I don't wine and dine all my clients like this. I don't take them to concerts. Gloria is not really Gloria. Gloria is Goldie. And Goldie is my mother. So once again, Gloria strikes. And she calls the show. And I say again, as I said a month or so ago, folks, please, it's almost Halloween. By all ghosts and goblins and witches and devils, please, don't let my mom be the only one to call me today on the show. Please, do me a favor, I beg you. All right, subject to any phone calls from any people who have pity on me, we'll go into a slightly different aspect of landlord-tenant law. Please, Greg, tell me somebody's calling.
Oh, I'm sorry. We're off the air. Oh, go ahead.
Oh, okay. Well, maybe, folks, I can sing to you. That might get you to call.
No, that's okay. That's okay.
But Greg knows. See, Greg knows. Greg knows you don't want me to sing. All right, so what about terminating the lease? What about, can you, as the tenant, terminate a lease early? What can the landlord do in terms of terminating your lease? There are some interesting issues here, and we can cover them, relatively simply, although, of course, I talk by the word, so, we could say in a paragraph what I could have said in a sentence, which is what most lawyers do when they're writing. I'm pretty flowery myself, especially when I'm being nasty. I love writing nasty. It's what I get. It's that thing I get after 36 years. The thing I enjoy most is being able to write a nasty letter and doing it in such a way as to be the most polite man possible.
I like that. Well, like our DC law firm, they're the nicest folks in the world at $500 an hour.
Absolutely. Now, I don't charge $500 an hour, but yes, people can be very nice when you're paying $500, $600, $700 by the hour.
Hey, Brian.
Big cities these days.
Yep, that's right. Brian's with us. Good morning, Brian. You're on with Stuart Address.
Hello, Brian.
Good morning. Hello, sir. I've been thinking about for a while. Let me see if I can make it make sense. So let's say I have a will, my last will and testament, which I don't know much about.
Greg, can you put the volume up?
Yeah. Can you speak up, Brian? You are really low.
Yeah. Okay. How about this? Better?
A little. Go ahead.
Okay. So let's say I've got a will. My kids are gonna, get all of my personal effects and money and all that stuff. I die, my kids get it, no problem. But let's say there's a great Uncle Scrooge McDuck that I never knew about, but somehow he knew about me and left me a bunch of money. Didn't know about my kids, he only knew about me, he left it all to me. Does that automatically go to my kids, or are they gonna have to fight that out? Is it gonna have to go to probate if it wasn't mentioned at all in my will, but it was left to me?
All right, not being an estate's attorney, I can still tell you this. Your will doesn't have to mention every account, known or unknown. If your will says, for example, that my estate will be divided among my 3 children, then your 3 children get 1/3 of your assets. If your great uncle that you never knew, Scrooge McDuck, happens to leave you a boatload of money just before or after you pass, it goes to your estate and would flow then to your children.
Okay. All right.
So if you have somebody out there who you don't know, well, your kids will benefit from it. And let me tell you one other thing. You mentioned personal effects. Yes. Personal effects, if you have a will, every time you want to change who's going to get what, you don't have to go change your will. You don't have to go to a lawyer and change the will. As long as your will says that personal effects will be divided in accordance with a paper to be found with this will, you are allowed to change that paper anytime you want. You can tear it up, throw it away, write a new one. As long as you keep it with your will, the paper that exists most recently to your passing, that's the one that governs. That's for personal property only.
Okay, all right. So and so would that automatically include, let's say, Uncle McDuck, World War II gun collection, or
Yes, that would be personal property. Yes.
Okay. All right. Thank you very much. I appreciate it.
You're very welcome. Thank you for calling. Okay. Well, I thank you very much for not having my mother be the only caller today. Happy to accept some others.
Yep.
772-340-1590.
And you've got one, Andrew. You're on.
Andrew.
Andrew, you're on with Stuart Address.
All right. Feel honored. Pleasure's all mine. It's not me, but my friends of mine who live down the street from where I live in Jensen. He was living year to year by a lease year to year. Now, ever since year number 5 went by, he had an agreement with the landlord that it would be on a month-to-month basis. They both agreed to it, and everything was honky-dory. Well, I come driving down the street, I don't know, 2 weeks ago or so, and I see these big notices plastered to the door, and I know that cannot be good. You're getting served for something, or it's a building permit. But anyway, now I just would like to tell him, it's like good news. Now, if it's month-to-month basis, do they have 30 days to be evicted, and then the sheriff comes in and say, pack your belongings and vamoose?
Actually, the answer is no, and I have that in my little list here. Let me find it for you. If it's a month-to-month tenancy,
Stuart's checking his voluminous note.
it's actually in my notes for today. Here it is. If you're on a month-to-month tenancy, it can be terminated by either the landlord or the tenant by giving no less than 15 days notice prior to the end of any monthly period. So if it's the 14th of November and you want to leave at the end of November, you can do that by giving that 15 days notice. If it's the 18th of November, then the 15 days notice starts December 1st. You can get out December 15th.
Okay.
But the notice has to be at least 15 days before the end of a rental period, if it's a month-to-month lease.
Oh, okay. You were talking just a little while ago too about damage deposits and
Yes.
security and all that kind of stuff. Now, if it's on a month-to-month basis, is that all that waived and that goes straight to the landlord and tough luck, Chuck?
I'm sorry, say that again.
When you were talking about like security deposits and all the first and last and all that kind of stuff,
Right.
have you? If there was damage to the property, where does it go from there? Is it the same thing like being under lease or?
Yes. The same rules follow. If there was a security deposit given, the same rules will follow in terms of the notices the landlord has to give and the timing of the return of any security deposit.
Okay, yeah, I just wanted to make sure, there was, because to me, there was a big fat line of gray between the black and the white in regards to a leasing tenant and a.
What was the reason for the notice on the door?
Pardon me?
What was the reason for the notice on the door?
I don't, you know what, I didn't delve into it, but from the inkling that I got was that the landlord wanted to raise the rent and he kind of knew that they probably couldn't afford it. And the first thing I asked my buddy was, are you in arrearage? And he goes, no. He goes, I paid him in full. He was prior to, but I spent every last cent and now the balance is zero.
Yeah, if you're on a month-to-month and the landlord wants to raise the rent, as long as the proper notice is given, the landlord could raise the rent. That's one of the benefits of being a landlord and one of the problems of being a tenant.
I truly appreciate your time on that one. So.
Oh, you're very welcome. Thank you for listening.
Because what he tried to do, just an ending point, was what he tried to do was to call the landlord's, or not call, but send his landlord's attorney, an email saying, hey, can we still continue this on? But I don't know what the outcome of that email being sent. So.
Well, hopefully they worked it out.
Okay, yeah, I do too, because they're good people and this and that, but legalities.
Well, thank you for the call. I appreciate it.
Have a great day. Thank you.
Take care. Yep, those are things that you do, worry about when you're a tenant, and there are things you need to make sure you're careful of and document. So, if the tenant breaches the lease in Florida, if you materially fail to comply with the rental agreement, the lease, other than for a failure to pay rent, we'll deal with that separately. But other than for a failure to pay rent, the landlord may terminate the lease on 7 days written notice if the non-compliance was of a type that you shouldn't be given an opportunity to cure it, and there isn't another violation within 12 months. So if, let's say, the violation was you were too loud after 10 o'clock at night, well, you should have an opportunity to cure that by not doing it again. So they can't just kick you out on 7 days notice. If they try to, you could fight that in court and you'd win. But if you drove your car through the front door, you're not going to get a chance to cure that by not doing it again. You're going to be out in 7 days written notice. So, you know, we can get closer to whether somebody should be given their opportunity to cure. You know, there are fact patterns that will be much harder to resolve. And that's where judges come into play. If it's really close, a judge is going to determine whether the tenant should have been given an opportunity to cure and whether the tenant will, in fact, be given an opportunity to cure because the judge simply won't sign a writ of possession. Now, in that situation, that 7 day notice that I just mentioned, again, there is a form that it must be in according to the statute. I won't read it for you word for word, but there is a form that, you know, very clearly tells you, the tenant, why you're being evicted or why the lease is being terminated, and then whether or not you will or will not have the opportunity to cure. Now, what if, as is most likely, or at least occurs more often than the other things, there's an issue of failing to pay rent. Well, that's not a 7 day notice, that's a 3 day notice. Because if the landlord doesn't get his money, the courts are very willing to evict the tenant quickly. So you get a 3 day notice, and if you fail to cure, the landlord could ask for a writ of possession. You will have an opportunity to defend yourself, but it is expedited. Now, people have called my office and said, the landlord says he's going to get me out in 2 weeks. Can he really do that? No, it doesn't happen that fast. Let's say you get the 3 days notice and you still haven't paid. The landlord's going to file the lawsuit. You're probably going to get notice of it within, 2 or 3 days more. There's going to be a date in that notice for you to appear in court. That date is probably going to be 2 to 4 weeks into the future. Now that is really fast for the court system. Okay, I mean, that is really, really, truly fast. But it's still, 2 to 4 weeks. And then you're going to go to court. And you're either going to argue why you should not be evicted and maybe win or maybe lose, or you will have moved out by then, which is what happens more often than not. You buy yourself some time and you get out during the period that the landlord is trying to get you out. All right, but what if you haven't got out? And what if you lose that fight in front of the judge and the judge indicates he's issuing a writ of possession that will then be sent to the sheriff, who will execute it? That happens quick. It all depends upon how quickly that notice gets from the clerk to the sheriff. That sheriff may be backlogged. That sheriff may have things that are much more important than serving residential evictions. And so it may get delayed. Let's say there was a giant, massive undercover drug bust in this small town the night before. He probably doesn't have many deputies to serve eviction notices, writs of possession. So you may buy yourself a little bit of time. But typically, when the sheriff gets that writ of possession, within a day or 2 or 3, a deputy is out serving it, and if you're not out, your possessions are going out onto the lawn, and the locks are being changed, and you're out of there. And that's truly an eviction. Eviction is a very well-defined word. It's going to kick you out. And so if you've gone through all the proper procedures and all the proper notices, and you've fought the good fight and you've lost, and you haven't made arrangements yet, you're in a tough bind because your stuff's on the lawn and you're going to need to get somebody there and either store it at a friend's house or get it in a storage closet real quick.
All right, I got a question for you.
You got a question, Greg? Okay.
Martin County is having a few problems at the tax collector's office. So say you were trying to update something in the office, whether it was auto or home, and that office is closed because of a internet, the international schemes that are prevalent now against cities and counties.
So you're saying, what if the office is closed and you can't do that which you must do?
Yeah. It's the Stuart, or I should say the Martin County Tax Collector's Office is being held hostage by one of those internet schemes.
Oh, Greg is saying the Martin County Tax Collector's Office is being held hostage by one of those, internet piracy, hijacking for ransomware type things. So what if you can't file whatever you need to file? Let's say, I don't know why you'd be at the tax collector's office as a tenant, but let's say it's the clerk's office. You're going to be given the additional time of grace. First of all, if the landlord can't file the action or get the writ, then you don't have to worry because it's not going to happen. And, during the height of the pandemic, that's essentially what happened. The order came down from the federal government that gave tenants of certain sizes and certain types protection from eviction. And that meant that the judge would not process them. Now, for a short time, even in Florida, our governor, who I'm beginning to despise even more than Trump, our governor put a moratorium on evictions, and courts were not processing them. Now, the landlord could file the eviction action, and the landlord could actually even take it to court, but the judge would then not sign a writ of possession. And if the judge didn't sign a writ of possession, it could not be transmitted to the sheriff. And if it could not be transmitted to the sheriff, you couldn't be evicted. Now, rent did continue to accrue. So let's say you were paying $1,000 a month rent and you couldn't pay for the next 6 months because you were out of work. So now you're behind $6,000. And now that moratorium on evictions is lifted. You owe that back $6,000. And if you can't come with it immediately or in a time frame that your landlord agrees, you're going to be evicted. It's unfortunately that simple. And a lot of people got caught in that kind of a web. But on the other hand, I had sympathy for landlords in that situation, because if a tenant is not paying and now they have this protection, federal or state, that they can't be evicted, I have sympathy for the landlord. The landlord's entitled to get the rent that has been bargained for. Even I agree with that. And if you're damaging the place, the landlord is entitled to be able to protect his property. Even though for the most part, I represent tenants. So, this whole pandemic has created a lot of issues where there's sympathy to the tenant, and there are issues where their sympathy really lies with the landlord. What if it's the landlord that breaches the lease? We'll do a peek here. Okay. If the landlord is the one who materially fails to comply with significant terms of the rental agreement, then you are the one that can give the notice to the landlord. Shoes on the other foot. But you can give a notice that 7 days after delivery of this notice, we, the tenant, are going to declare this lease terminated and move out unless you fix A, B, C, D, and E. And if A, B, C, D, and E are things that the landlord is required to do under statute or under the lease, and they're not fixed within 7 days, you have the right to terminate the lease and move. Unless this is the area, this is what I love. This is what I went to law school for. The unless, always an exception. Unless the landlord is taking active, substantial steps to make the necessary repairs and has been unable to complete them either because of the scope of the repairs or because, let's say, a hurricane came through. The landlord is going to get additional time that is reasonable. How is reasonable defined? Wherever the judge defines it. It's whatever the judge says. So, if the landlord is not fixing your toilets and you can't use them, I've actually had a case like this. That is a material breach, and that actually makes the house unsafe to live in. And if the house is uninhabitable, you can terminate the lease, move out, and you have no further liability for rent. If, let's say, he's not fixing the drain and the sink, you can't just move out. That does not make the place uninhabitable. Believe it or not, under Florida statute, the landlord is responsible for heat, but not air conditioning. I don't know where these people were from when they wrote the statute, but the landlord is responsible under statute for heat. But there is no requirement that you be provided air conditioning. So if the house is too warm, that's not the landlord's problem unless there's a provision in the lease where you bargain that the landlord's going to take care of the air conditioning. But if it is February and we're going through one of our cold snaps and it's going down really low and there is no heat in your apartment, you have the right to, you got to give them notice, but under a situation that serious, you have the right to protect yourselves and your family. You have the right to leave. Okay, and if the problem is not repaired in 7 days, to terminate the lease. But even if the problem is repaired, if the place is uninhabitable for a period of time, you have the right to leave the premises and not pay rent for that period of time. Now, we'll often get into fights with a landlord over whether you're entitled to that and how much you're entitled to, but that is the law. That is what you're allowed to do. So landlords can try to make repairs and not finish on time through no fault of their own. You got to give them more time. Landlords can try to make repairs and not finish in time, and you might be able to terminate the lease. And a landlord who leaves a premises uninhabitable allows you to leave and terminate that lease quickly. You still got to give the notice, but you're not going to be obligated for rent as of the date of the notice, not 7 days hence. I had a client recently who there was a flood and they called in, water removal and mold remediation and everything, all the personal furniture and personal effects were pushed into a back room, which was cut off with the plastic and taped up so that there was no access to it. And there was no access to the apartment for a period of time because water remediation was there removing water, and mold remediation was there fixing mold. That place is uninhabitable. And you can terminate the lease. Now, it so happened that his lease was ending in 30 days. But if your lease had 8 months to run, that situation allows you to terminate the lease. This is why lawyers exist. Legislatures write laws. Legislatures sometimes write laws that are confusing, and legislators often write laws that are stupid, like not making air conditioning a requirement in Florida. But heat is. Thank you, legislators. Let me tell you quickly, I'm going to jump around my outline a little bit. We only have a couple minutes left. There is a 2020 Florida statute, Tenant Protection from Foreclosure Act. It was enacted in part because of the pandemic. Let's say the landlord is being foreclosed upon. I'm going to do this on the surface level, and maybe next Friday we'll go into it deeper. Let's say a landlord's being foreclosed upon, and now there's a new owner. Do you have to go? No. The new owner has a certain amount of time that he can give you, 90 days to get you out. Or in different circumstances, which we'll discuss in detail more next week, the new owner must take the property subject to the leases and allow the lease its normal expiration before they can get you out. Or the new landlord, the new owner may be able to get you out really quick if it's their intent to reside there as their primary residence. So there's all these different things and reasons, and they all have different time periods of notice that must be given. But this is a new statute that was enacted just last year, and we were getting calls. We were getting calls that, so I rent this place, and the landlord's lost the house, or the landlord's lost the apartment building, and now I'm getting notices to pay my rent to somebody else, and I have this notice that I need to get out within 90 days. Can they do that? Well, the answer is not a simple yes. It depends. Then we go and look at the statute. We look at the reason they're saying that they're kicking you out, and then we can advise you whether or not they can kick you out within 90 days, whether they have to wait until the lease is over, or whether maybe they can kick you out within 30 days because they're going to move into the place and live there as their primary home. And once again, this is why we always suggest it's not just to make money. Ask a lawyer. There are so many things that come up in daily life where I see that people could have helped themselves, landlord, tenant, anything, contractors, they could have helped themselves had they asked a lawyer. Now, you want to know something? Lawyers often charge for consultations. I do too. If it's of a type of case, there are certain consultations that are free. There are others that we charge for. But even when a lawyer charges for an hour consultation, you will probably get a little bit of information as a result of a telephone call. And that little bit of information may be enough for you to decide whether you want to pay a lawyer for a half hour or an hour's consultation, or whether it's not necessary. You may have gotten enough information that you're satisfied. So at least try to ask a lawyer. You never know how much information a lawyer may be willing to give you for free. Got problems, contractor, landlord, tenant, estates, whatever it is. Don't just try to handle it yourself. Try to ask a lawyer. It may save you a lot of time. It may save you a lot of grief, and it may save you a lot of money. And, being that it's Halloween and we have to buy candy, we all need to save money. Anyway, I'm being given the googly eyes by Greg that I got to go. So have a lovely Halloween. Have a lovely week. This is Stuart Address for Ask a Lawyer. I'll be back next Friday. Bye-bye.
WPSL, WSTU, Port St. Lucie, Stuart.
Is CBS News on the Hour, sponsored by Facet Wealth.
I'm Steve Kathan. President Biden in Italy. He met today with Pope Francis.
The only footage of the meeting from a Vatican camera has the president introducing Pope Francis to his senior staff. Aides say the president and the Pope developed a clear rapport. Mr. Biden was heard joking with the Pope about his abstinence from alcohol.
I'm the only Irishman you've ever met who's never had a drink.
In a more somber tone, the president presented Francis with a challenge coin, which he described as a tribute to his late son, Beau.
I know my son would want me to give this to you because on the back of it, I have the state of Delaware.
Stephen Portnoy, CBS News, with the president in Rome.
Well, the Pope called the president a good Catholic who should keep receiving communion. Later in Scotland, Mr. Biden will attend a climate summit on this trip overseas. Andrew Nasdin is with a group that's pressuring leaders to take bold action.
From wildfires in the U.S. to flooding across the world, we are in a full-blown climate crisis. World leaders know this. They've seen what's happening. Now's the time for them to come together here in Glasgow and hammer out a deal to avert